Second in a series of blogs regarding a pending litigation in the federal court. It involves two insurers, an excess insurer suing a primary insurer. But what is most telling, perhaps most relevant to you, is how these two insurance companies viewed a case. And their focus first and foremost was on their bureaucratic needs, the litigation status report. And over a 2 or 3 year period, they wanted that report to be sent to them on a regular basis. It's amusing to me that they didn't seem to care whether it was updated to reflect changes in the course of the litigation, changes that would show how a deposition might have changed the course of the litigation. But no, the insurers seemed to want a 30 or 60 or 90-day update and seemed less concerned perhaps with the content. Now that assessment came about very early on in the case as an insurance company had their expert review what happened, and he concluded that it was my client who was at fault. Amazingly, that assessment seemed to control the defense lawyer and controlled the insurance company in how they thought they would prevail, that they thought there was a very strong likelihood that they would prevail at trial, and thankfully they didn't, and they lost rather handsomely. But what amazed me is the insurance company so clung to this assessment by their expert that they paid no attention to what would happen if a jury believed my client and felt that the representatives of the defendant were lying. And how somebody could seemingly assess that and assess it in a vacuum is beyond me. Consequently, about $10 million has been spent because of this rather significant mistake by the insurance companies in reviewing the case. But ponder for a second, if you will, how out of touch it is to think that a specific standard will automatically govern and influence 12, actually there were 14 people who sat on that jury, and influence them, even though a jury could well make a determination that one side was telling the truth and the other side wasn't. And if it happens in that way, I say to you, the legal standard, or the standard in the industry actually, is far less important. So what was revealed to me in these binders of documents, an amazing amount of paperwork, is not once did I see any evidence in what is now public record of any attention to real life situations, but rather an automatic clinging to a standard that had little relevance to a jury. Thank you.